Ann Pawson. I am a Florida elder law attorney, and this is
Tyler Runty, and I'm a Florida elder law attorney as well.
And we're going to answer the question, what are the 5 things we would never do as elder law attorneys? So I'll take number 1, which is we will never add a child's name to a bank account as an owner. A durable power of attorney is a far better way to address the issue. So if you want your child or another trusted friend to be able to sign checks on your account and access your money if there's a medical crisis, a durable power of attorney is the preferable way to go. It's not gifting. Adding kids' names or anyone's name to a bank account has so many problems involved in that. And number 1 is Medicaid considers it a gift. So gifting is a no-no in the Medicaid world, and it makes the Medicaid process that much more difficult.
So another one that you don't want to do is have an irresponsible kid on a power of attorney. This is the person that's going to be making legal and financial decisions for you. So you don't want to have someone irresponsible doing that. Not only could they take money out of your account, of course there could be recourse for that, but you want to make sure that you have someone that's responsible, that you trust, that is going to act in your best interest.
I think the 3rd thing would be adding someone to the deed to your house. So it's very common. Mom and dad have been married 60, 70 years. Dad passes away first. Mom isn't very knowledgeable in anything legal or business. And the oldest son says, oh, attorneys are terrible. Just add my name to the deed to your house. And then if you pass away, of course, I'll inherit it outside of the probate process. And of course, I will sell it and share the proceeds with my siblings. Well, that rarely happens in our office. There's a number of reasons why we would never add a kid's name to the deed. One of which is mom could lose her homestead, her Florida homestead, if the son is, let's say, a New York resident. They also lose the tax advantages. They lose the stepped up and cost basis if mom or dad passed away, as well as adding your kid's name to a deed is a one-way street. People will come back all of the time saying, when my husband died, I added my oldest son to the deed because he said it was the right thing to do, and now I'm mad at my son and I need to take him off. Well, the only way to get him off is for the son to willingly sign the deed back over, which rarely happens. So there's multiple reasons why we would never add a kid's name to a deed. Besides the gifting, back to the Medicaid, gifting is a big headache in the Medicaid world.
Which touches on number 3, giving away money. So on the Medicaid side, you don't want to gift away money. That's something that would have to be cured or undone. So you don't want to give money to your kids. You never know what your life is going to hold. So you really want to have your money. You may need it in the future, even if kids are, I need this for a new house or I need this for my kids. You need to keep your money and use it how you need to use it.
I always tell people your kids can have all of your money after you pass away, not before. The 5th thing is people not planning. So in our office, we do what's called proactive planning for the assets, and we also do crisis. So when we're in a crisis situation, our things are limited. We don't make the best decisions in a crisis. A lot of times we get hired in the crisis situation all of the time. I have 2 full-time employees doing nothing but crisis Medicaid at this point, and it's not the best place to be, and I would much rather have proactive planning. So proactive is, okay, mom or dad are getting older, they're starting to have some medical needs, let's take a look at the assets and the income and where they're going to live and those sorts of things, and have a systematic approach to the aging process.